Hello, everyone. Good evening, and welcome to yet another episode of ICPA Clinical Series. You all know we are in the season number 2, and today is the fifth episode. And the theme for the day is driving innovation and fostering growth. So, today we have picked up a very unique topic, very useful topic for those who are interested in innovations. And for this, we have got two guests with us. One of them is a great innovator with multiple intellectual property rights to his name, Dr. Rajshekar Halli, and Dr. Bhavdeep Singh Ahuja, who is our technical expert. Let me introduce our guest speaker, Dr. Rajshekar Halli, first to you. Dr. Rajshekar completed his BDS and MDS in oral maxillofacial surgery from KLE's Institute of Dental Sciences, Belgaum, and then he taught in the same college for 7 years before moving out to Rural Dental College, Loni, where he taught for another 4 years. And then for the last 15 years, Dr. Halli is working as the professor in Bharati Vidyapeeth Dental College, Pune. Dr. Halli has also received advanced training in oral head and neck oncology from Kidwai Memorial Institute of Oncology, Bangalore. He has also received specialized training in craniofacial clefts at the Charles Pinto Center for Cleft Lip and Palate, Jubilee Mission Hospital, Thrissur, Kerala, under the guidance of Dr. Adenwala. He has also undergone ATLS, that is Advanced Trauma Life Support Training. And recently, in 2019, Dr. Halli cleared his MFDS RCPS in oral maxillofacial surgery from the Royal College of Physicians and Surgeons, Glasgow, UK. Of course, apart from all these accomplishments, he is here to tell us about his unique feat of owning 9 patents and 3 copyrights for his original work, about which I will not speak. I want all of you to hear from Dr. Halli himself. And of course, we also have Dr. Bhavdeep Singh Ahuja with us today. Dr. Bhavdeep runs a successful dental practice at Dentec Smiles Dental Clinic and Implant Center, Ludhiana, Punjab. And interestingly, Dr. Bhavdeep holds a triple MBA from 3 premier institutes of India. He has an MBA in hospital management from IIMM Pune, an MBA from finance and human resources, dual MBA from Indira Gandhi National Open University, Delhi, and the third MBA in marketing from Annamalai University, Chennai. Dr. Bhavdeep also holds postgraduate diplomas in diverse subjects like medical law and ethics, clinical research, cyber law, disaster management, financial management, and bioinformatics. He also writes and lectures extensively all over India on practice management, medical law and ethics, and finance for dentists. Of course, I, as the executive editor of Dental Tribune South Asia, keep inviting Dr. Bhavdeep to write multiple articles every year, and he has been writing excellent quality articles for Dental Tribune. All right, but he is here today because he also holds a postgraduate diploma in IPR, intellectual property rights. So we have invited him to grace today's event as the technical expert. So now I request Dr. Halli sir to start his presentation. Dr. Rajshekar Halli, your slide is already there on the screen. You can start speaking. Till then, I'll take myself and Dr. Bhavdeep backstage. You can start, sir.
Okay, yeah. Thanks, Rajiv, for the wonderful introduction of both the speakers. At the outset, I'd like to thank ICPA and Rajiv Cheggopi for giving us this opportunity to present whatever has been done by us. All right. So my slide is visible, and am I audible?
Yes, sir, very much. Everything is
Hello.
perfect.
Okay, fine. Okay, let's start now. So just to briefly introduce what is intellectual property, this pertains to any original creation. I have put original in capitals with the purpose because all these IPs should have a originality of the human intellect, such as artistic, literature, technical, or scientific creation. And what are IPRs? That is intellectual property rights. That refers to the legal rights given to the inventor or the creator to protect his or her innovation or creation for a certain period of time. I'm sure all these details will be covered by Dr. Bhavdeep sir at a later time. All right. So there are many types of IPs one should know, and as a dental fraternity or a doctor, which suits us, I'll be telling you in the further forthcoming slides. Right. So these are the types of IPs that are available. One is patents. In that you have again a design registration, and there is something called as a utility patent. All right. Then you have industrial designs, trademarks, copyrights, GI of source, that is geographical indication, trade secrets, this SICLD, semiconductor integrated circuit of layout designs, protection of plant varieties and farmer rights, and last one, protection of biological diversity. So you have basically 9 IPs that are possible. All right. So let me tell you my journey, how I got motivated. Probably Rajiv stressed a lot on this thing to tell you all how exactly I proceeded with these IPs. Okay. So I had enough number of publications. As of now, I'm close to 100 publications, where about 49 are Scopus indexed and 48 are PubMed indexed. Okay, so I wanted to do something different apart from these publications which are routinely happening. Thanks to DCI actually for making it mandatory publications for your promotions and diligence. Okay, that is how many of the publication numbers are increased in India. All right. So I wanted to do something different. So always, if you want to do something different, you should have few ideas, or sometime you get that one spark. All right. So if at all you get such an idea or a spark, the first thing you should do is to search whether anyone else in the world has already attempted or published or copyrighted or patented whatever ideas you have. Okay, this is very, very important. Otherwise, all your hard work will go waste, because this is going to get rejected. So once you have searched, then you have to execute. Right. So I've been in the academics since almost 20, close to 26 years. So always remember, the innovation should ease the life of the people. I had heard some motivational speaker who said that if you can touch 1 million people with your innovation, so that is a great entrepreneurship. All right. So being in academics for 26 years, I wanted to do something which is very student centric and makes life of student very easy. So probably all my KLE friends or students know that I was little good in handwriting and also drawing. So if you remember, during our BDS days and MDS days, we didn't have any PowerPoint or slide presentation, things like that. We used to present all the seminars, all the lectures on something called as OHP sheets, wherein we had to write on our own and draw the diagrams or representations on our own. All right. So in our field, these skull models like frontal view and the lateral view and the mandible are very, very vital for the for educating the BDS students or the MDS seminars. Okay. So I wanted to do something in this field. That was a spark which I got. Then what I did was, one day I was sitting and then I took a OHP sheet, all right, the same one which we used to present, and then cut it in this format which you can see on my slide now, all right, which are actually depicting the diagrammatic representations. Right. So now if you see the lower half of the slide, so it is very easy to draw these skull diagrams and put in your presentations of the specific diseases like cysts, tumors, impacted teeth, and various fixation sites, and how many plates you use, what you do, okay, all these things. So this actually, if at all, can be used by students. Students can very well easily draw the diagrams in matter of no time. Okay. So one of my friends said I took his advice. Okay, he wanted his name to be anonymous because I can't reveal. So he said you better get these patented before anyone else attempted. So we both sat and then searched the literature and all the databases. There weren't any of these such templates were available for as an education model. and then I patented all the three models. All right. So the advantage of doing such thing is you can actually commercialize these products and take the royalty also if you have that kind of intent. Right now, this is being approved by one of the industrial partner now. So this will go into bulk production very shortly, and then maybe at a later date I may get a royalty. Now coming to our further journey, again, you all know as a max fac surgeon, lot many trauma cases we get day in day out, and we are always in a jinx to which kind of plates or screws should be used for that particular fracture. So everyone knows this tension zone, compression zone, then lines of osteosynthesis of Champy, all these things. So the major issue comes when you have an angle fracture. All right. If you can see my slide here, the lower middle one. All right. So this particular strut plate, angular strut plate, was designed by me. The biggest mistake I made was I didn't patent it at that time. Okay. So what I did was we designed this, and then we got it printed, and then we used in couple of cases and compared with other type of fixation methods, and we actually published in a AO journal, which is a standard international journal. All right. And what happens in such cases, had I been known that we can patent it before we publish it, I could have patented it. But now, by then, it was too late, because once you publish, you lose the copyright. So you actually surrender your copyright to the journal itself. So this design again, actually I had drawn. Then later on, AO said no, that won't work. So they did all these diagrams, and then we could publish. So this later on, when I came to know that we can patent such things, now I started searching what best other plate system can be done. So we did a lot of FEA studies, that is finite element analysis studies. So if any of the maxillofacial surgeons are listening to this lecture, or even the dental surgeons, we know that minimally displaced angle fractures can be managed by a single plate at the superior border, which can be easily placed intraorally. All right. But issue was there are lot many torsional forces that are happening at the angle, and this single plate is not enough to give good amount of rigidity. So what I did was I added these two arms for a single plate, and then these two arms gave a good three-dimensional fixture, and then I patented this plate. Okay, one on the left side and one on the other side. So now again, this is undergoing a bulk production for usage, so it will be available from November 2024. Now that was a very short explanation due to paucity of time regarding how exactly you can proceed with the patents. Now let's go to the copyright aspect. So I always had a habit of writing notes. I think many of the KLE students or ex-students know this, because many of my notes are in circulation. One fine day, I had gone to Manipal Dental College as examiner. All right. So if you we all remember that during our BDS days, we used to get notes from Manipal, and we used to study those notes. But when I went to Manipal, I was shocked to know that my notes were read by their PGs or their students, and then they used to give exams on that. So I was very happy. Then a few of them suggested that I should publish books on whatever notes I have written. But then I thought books being already published, and there are many standard books that are available. So what I thought was I should take some selective data from my notes, and then try to do a copyright of that particular selective data. All right. So one data I took, and then I searched the literature. There weren't any copyrights on that particular selective data, and then I approached my mentor, and then we executed. Okay. So this is how things or motivation come to you. All right. So the most common procedure done by max fac surgeons, everybody knows that wisdom tooth removal or the third molar surgical removal. So we all go via strict surgical principles, but sometimes deviation is good or beneficial for you if at all it is working in your hands, and which has to be published or copyrighted and passed on to a public at large. Okay. So what I did in this case of copyright was I used to use a reverse forceps for maxillary third molar or the mandibular third molar. We use the maxillary forceps. So vice versa. All right. In few select cases, believe me, it works wonders. All right. So then I searched the literature. There weren't any publications on this topic, and then I copyrighted this principle. Going to the next one. So we always carry out various suturing techniques because any surgery definitely ends with a suturing. And we keep on reviewing the results after a week when the patient comes for suture removal. Luckily, whatever cases I used to do earlier, I only used to remove the sutures. So then I thought in some cases there were gaping or there were some complications that were happening. Then I started doing some modifications of these suturing techniques. After I did these modifications, I again reviewed the results. All right. So these results were little better than the previous standard suturing techniques. So this again I established and then I copyrighted this edge to edge suturing. So we all know we can, being a max-fac surgeon, we know that we need many diagnostic modalities for various cases or surgical cases. And the most common diagnostic modality is a OPG. If at all patient comes to you, then we send for OPG saying that, "Chal, yeah, we can get all four wisdom tooth in a single X-ray and it can be viewed better." All right. So we see the relevant details. Supposing there is an impacted third molar, we see all the relevant details and enlist them. All right. So I try to search the literature wherein is there any checklist for such a X-ray that you need to check all this if at all that diagnosis has to be taken place or made, and depending on that the surgery can be planned. So I couldn't find any checklist. So what I did was I designed my own checklist for OPG. Also, I have one for the IOPA as well. All right. And then I executed and then I copyrighted this checklist for OPG. Now we all know evolution is a constant phenomena. Okay, so we all remember what kind of mobiles we used to have earlier, bulky ones, and where we have evolved, and then what kind of mobiles we now have with slimmer ones and which has a multiple or better features than the older ones. Eventually, we also in our surgical technical area we have to evolve. All right. So now what I'm doing is my son is an electronic engineer, and then I'm collaborating with one of the IIT Mumbai professor. All right. So what came to my mind sparked was we used to carry such a huge micromotor. All right. In all the cases, whenever we went for visiting or to the OT, all this. So then I thought, why can't we minimize this? When a mobile can be miniatured and giving so simplistic and good number of features, so we can minimize. Then we search the literature. We could get only bulky ones. Now the slimmer ones are also there. Now we are planning to design this IC. It's called integrated circuit. All right, in collaboration with the electronic engineers. So once if the prototype is ready now, all right, so once it is successfully tried and tested, so we want to patent this. So always remember, you can't do things alone. You have to have a good number of team members for a good outcome, right? Now I'll end my journey. It's another long journey again. Of course, I have nine, and then many are in pipeline. Okay. So as Rajiv had put the right title for this presentation, whys and hows. Okay. Why you should do patent. So as I told you, you can do many publications and things like that. This IPR actually improves your CV. If at all you are applying for job or any other ventures, so this actually improves your CV. And if you have an intent of commercializing some of the products or getting a brand value, this is a great invention, right? Then hows, I've told you, you have to be different or at least think different from a routine person, because people say if you think something, already seven people in the world have already thought about this. All right. So you have to be different, and then if at all you get that spark, so immediately you go search the literature. If none of them have done, then immediately you copyright it or you do the patent. All right, always remember, you have to go in with a systematic approach. You should have a mentor. Not that we cannot do on our own, but definitely these things simplify your things, right? So now we have many more in the pipeline, and then, as I said, you should have a right approach, right guidance. It's always a teamwork, and you should always acknowledge the stakeholders who have helped you. Right? Thank you, Rajiv. Over to you.
Thank you, sir. Thank you. A lot of work that has come above the surface and become an intellectual property right. You have taken two types of intellectual property rights: patents and copyrights, and some of them are very complex. And at the same time, I could see that a simple checklist can also be an intellectual property right. And
Yes, yes.
thing is, it
That's
makes things very, very what you can say, systematic and applicable. So that's how it becomes different from, you are actually taking out from the chaos and making it very, very applicable in the real world. You are actually solving people's problems. So that's great achievement. Kudos to you. And now I hand over
absolutely.
the session to Dr. Bhavdeep Singh Ahuja, our technical expert, who can add a few more lines from his expertise before we start taking questions from our registered delegates.
Thank you, Rajiv. Thank you, Dr. Rajiv. Wonderful presentation, Dr. Rajshekhar. Actually, it was mind blowing to see very simple things also getting into the, you can say, the privileged columns of your CV as well, I would say. So, yes, definitely it adds on to the CV. There are multiple ways where we can document things, where we can save it for future. And yes, Dr. Rajshekhar mentioned about 9 types of IPRs or intellectual property that can be used. He's actually using 4 or 5 of them already. So the basic three which are common to us as dentists could be copyrights, trademark, and of course the patent. So two of you have already heard, you heard about the SICLD design also, which he's making for the micromotor as well. So let me just brief you what exactly is the difference between a trademark, copyright, and you can say a patent. So a trademark is basically your brand identity. It is an expression of your sign, brand, logo, or you can say even your signature. It can be as trivial as that. Copyright is something, an expression of interest, whichever you want to do in your professional space. And patent means you become an owner of certain kind of techniques. So there are different acts which are governing them, and they are, you can say, applicable. The Patent Act is 1970 Act, the Copyright Act is 1957 Act, and the trademark is the recent one, 1999 Act. So trademarks, once done, they are applicable for, you can say, an infinite number of time. Copyrights are valid for up to 10 years, patents up to 20 years. Of course, renewable every year, every one of them. So they come with a little bit of cost factor as well, which I'm sure there will be some questions as well, which we'll be taking up. So this is the broad differentiation between these three. And the processes, when I studied these way back in 2014 and 15, it was a lot complex at that point of time. It was more of a physical filing, had to make a lot of rounds to the government departments, and you know all how things work in the government department. So that is how it was there. But now recently, especially post COVID, things have been digital. It is more of an online thing now. So you can do everything from the comfort of your home as well. And yes, there is always an option, get it outsourced to a third party or an agent or an official one. That again, the option lies with the stakeholders or means the dentist himself, whether he wants to invest his or her time in that or wants to outsource it. Over to you, Rajiv.
Great, great. So I think the viewers have got a clear distinction between patent, copyright, and a trademark,
Trademark.
and how for how long they are going to remain valid and how you can renew. And thanks for adding that a lot of things have become online and they've become very, very convenient. And thank you for adding those precious bits, Dr. Bhavdeep. So, what we'll do now is we'll take questions from our registered delegates. And before we finish this section, if we get some questions from our live viewers, then we'll take them up later. Okay, starting from the first question, I think this is from Dr. Mejo, and he says, I think you have answered it, but I don't mind hearing it again. Dr. Halli, what is your motivation and what was the drive in acquiring so many patents? How did it all start? This answer will help
I
those
think
who
I
joined late.
I think I have answered this. Maybe again I'll answer.
Yes,
So as Rajiv also said and Dr. Bhavdeep also said, you have to be different. So once you want to be different, then you will definitely hunt what is a better way to be different than the general public. All right. So as I mentioned, I had enough amount of publications. Then I wanted to make something different. And being in academics, wanted to make something good and easy and student centric, and it should be cost effective also. So all these things drove me. And being a max fac surgeon, so again, as I mentioned, many of the plating systems I've already designed. Few of them are patented and few of them are in the pipeline. And these eventually come into bulk production. And at a regular rate, I'm not taking any royalty from the manufacturer. All right. So because these will be used in poor patients, so they will be helpful at large. Yes, Rajiv, thank you.
great, great, sir. So, a lot of technical questions here. Dr. Bhavdeep, if you can answer this, basic steps of applying for a copyright, how to decide whether we should go for a copyright or a patent. Should we apply it ourselves or trust a third party who charges a lot for a patent application?
Uh, it is very easy to distinguish. See, once we have the patent thing, patent is predominantly, you can say, available in three options. I would say the design form, the ornamental form, and the plant form. So design is basically when you are dealing with an equipment part, something, or maybe for example, a design part of any uh, existing equipment that we are using. Then the ornamental is basically designing the shape or the, you can say, whatever the morphological characteristics which are there, which can be changed. So we predominantly fall into these two categories. So patent is where you become the owner of the invention. It is kind of an invention for you which is not existing anywhere, and you become the owner of that patent for 20 years. More or less it is the same. It can be more in a few selected cases, but then what we are sticking to is approximately 20 years. Having said that, the process firstly begins with your search. What are you looking at? As Dr. Rajshekhar also mentioned very clearly, you have to be a bit different. And whether your domain where you want to apply does exist or not. So which is the way to go? The government website ipindia.gov.in. ipindia.gov.in, that is the basic starting site. There is a subdomain of that, IPR search.ipindia.gov. So you can search for the IPR whether what are you looking at is available there or not. And then the pathway is easy in that. I mean, both the you can say trademark and the patent can be done from that part also. Of course, can be outsourced, but just look at the volume, you can say, of the fee structure, because the patent is a long process. It is not a process which will finish in a few months. It can take up to some good as 2 to 5 years as well, which means you have to apply first. You can say even in the provisional stage you can apply for that. And the government fees is just about 5,600 rupees, 5,600 only. But whereas if you outsource to a third party, depending upon whatever you are looking at, the cost can go up to as high as 1.5 to 2.5 lakhs, maybe even more, depending upon what kind of this invention is. But yes, When you apply, for example, you search for it on the IPR search IP India website, you found that it is not existing, and then you start working on it, apply for it, and even it is in the provisional state, you upload it, and then you can, of course, within 1 year, you can upload the remaining documents as and when your discovery or the stage gets closer to completion. So you have about 1 year's time, and then the government process begins of, for example, we know about the FIR, first information report, which is done in police stations. Here we have a FER, first examination report, which is done mostly in the government offices, and there the examining officer examines it whether the, you can say, there has been any opposition to that, where are there any, you can say, crisscross matches with any previous inventions, and then that is published up to in about 18 months of time, or 1.5 year of your completion of the uploading of the documents. So once there is no opposition and everything is clear, you can say various stages, then you are accorded a patent for 20 years. Every year the patent has to be renewed. For the first few years, first 5 6 years, it is about 800 per year, goes up to 1600 per year for the next 5, 2400, 3200. And whenever you apply for a patent, approximately 30 pages of your paper, and you can say 9 claims are free of cost, and included in that initial government fees of 5600 rupees. But beyond that, every page is 160 or 300 rupees chargeable, depending on what you apply. So your starting way is go to IP India, read about it. There are a lot of FAQs listed over there, which can give you a clear amount of idea. And as Dr. Rajshekhar mentioned, it adds to your CV also, it adds to your brand value also. One tip, being a finance coach, I'll give you, whatever you earn out of royalty under section 80 RRB of the Income Tax Act, you can get up to 3 lakhs of deduction over and above all your 80Cs and 80Ds and everything. 3 lakhs of deduction just from the royalty income. Can be from books, can be from patent, can be from discovery, can be from trademark, whatever. You can do it. So that is the journey to go about the patent part. For the, you can say, copyright part, you can outsource it as well. You can outsource it to someone for use as well. For patent, if you have to outsource it, then that person becomes the owner of that. You can outsource it for, you can say, selling also, for branding also, for many purposes. But yes, it cannot be leased. It has to be then transferred. Then that individual or the company becomes the owner of that patent. You can sell it. It is your IPR, of course. But the last point in this is, other than the finance part, whatever your discoveries are, you can say, in terms of patent, trademarks, or copyrights, they are valid only in India. You can opt for an international if you want to go, we can say, international. Courtesy the World Intellectual Property Organization, WIPO, it has a member treaty of, we call that as the PCT, Patent Cooperation Treaty, which was done in 1970, and about 150 countries, odd countries, are member of that. India is also a member of that. For that, if you have to apply, you don't need to apply to separate countries. You can apply in your India office only, pay the fees in US dollars, which is close to about 15 to 1600 US dollar, keeps on rising every year, which is close to 1,25,000 Indian rupees. So you got the, you can say, aim in that. What is the patent cost? Government is 5600. Outsource it to an agency, 1.5 to 2.5. Want to go international? The only the official fees is about 1,25,000. Now this is about the patent. Going for the trademark, copyright, approximately in the range of 4,500, 5,000, approximately that range. So I hope that
Great.
answers.
Yes, absolutely. So, in short, if somebody wants to take a patent, gets a patent, it's up to him whether he wants to use it for his own branding or creating a product out of it and commercialize himself. If he cannot, he can simply transfer the right to somebody else, who in turn becomes the owner of that innovation, and then it is up to him how he wants to commercialize it.
Absolutely, absolutely.
Great, great. Thank you so much. Moving on to the next question. If two studies are going on simultaneously and both of them file for a patent, will there be a problem? And if at all it gets awarded, who will get it?
See, the primary thing is, usually when the studies are exactly similar in nature, and the documentation is almost similar. They give the option to both the parties that both can become co-owners or the joint
Okay.
owners, which means both of them will have 100% each or 50% each in that case. But if somebody you can say, I won't use the word in that sense, but if somebody is egoistic about it, that I know I applied first, I want to do that, then whosoever has chronologically in time frame applied first and has a complete documentation gets the first right over that patent.
Okay, so there are criteria in case of a tie. They know how to
Right. They know
choose
how to
one
use it.
person over the other. Okay, great.
Yes.
Next question. Can somebody apply for a patent of just a design or concept of an appliance?
Yes, as I said, it is available in design also, in ornamental also, and in cases of plant discoveries also, as I mentioned. So, if you believe that your innovation is unique, search it out on iprsearch.ipindia.gov.in, and you will find it, whether it is listed in there or not. Dr. Rajshekhar mentioned it well. Even a simple thing as a checklist can be a part of that also. So design is definitely way above that, and you have to check out the register whether you are applying for does hold value or not.
Yes, exactly. Great. Procedure to register a patent, I think it has been told in detail. Uh, how to sell your IP?
How to sell your IP again depends upon what is the purpose for which you did it. If your purpose is the CSR, the corporate social responsibility, as Dr. Hali also mentioned in a few things that he has made something for the poor patients as well. That defines the motive. If you have made it for your own branding, that defines the motive. If the third thing, you can say the money is the motive, then that also defines it. Yes, you can outsource it, you can sell it, you can say give it to someone who becomes the owner, and you can enjoy the fruits and start working on your next discovery.
Okay, great. No, the thing is, I think this person who has asked this question wants to know. Suppose he has got a patent thinking that he will be able to commercialize. Now he tries for 4 or 5 years, then he realizes that it is not his cup of tea. He wants to transfer it. Okay. Now he wants to sell it. How will he approach? Where to approach? On what platform he should send out his message?
See, a buyer definitely needs a seller first.
Yeah.
So it's not about the platform, it is about the discovery, which is what it is. For example, as Dr. Rajshekhar mentioned, if it is a plating kind of a thing, the companies who are making those plates would be interested in that. If
Okay.
it depends upon who your seller is or who your, you can say, customer is in that sense.
Actually, who you wanted to become like? I wanted to become like
Yes,
an implant seller. If I cannot do it, I should be contacting that person first, whom I was trying to imitate. Great.
absolutely. Yeah.
Okay. Next question. Suppose I have got an IP, either a copyright or a patent. How to promote ourselves once we get that? How to promote ourselves? How to brand
See,
ourselves basically?
brand ourselves again. The social media is the first platform where you can say sing your tune. The website is the second tool in that, and of course, again, the purpose needs to be, you have to find out your why. If your why was to, yes, get the limelight only, then be happy with that. If your purpose was selling, then be, you can say, find the buyers, or the seller, you be the seller and find the buyers. If your purpose was, you can say, reaching out to the poor as a part of your CSR, then reach out to someone who is into the space, who is holding the ground for such things. So again, the why is very important, because most of the discoveries start with the first aim of the limelight, and second, the money part. Other things come later into the picture, and those things eventually may become important, but primary to starting, you can say, driving factors are these only for younger generation, I would say.
Okay. And as far as the social media thing that you said, if somebody has got a patent and if he is looking or a copyright and he wants to promote himself, from my side, the recommended platforms are LinkedIn and Twitter to start with. Later, we can always move on to the Facebook, Instagram family of platforms. But for me, LinkedIn and Twitter will get you a lot of organic reach. All right.
Definitely.
And next, there is a long question. I hope I get the relevance right when I read it. If a company demands IPR authority during the official agreement period, say 1 year, and also copyright authority of all that is created by a doctor in collaboration with that company during that time, then what are the limits understood by the intellectual property rights? And during this time, if the doctor creates any content or especially any study material that is not in collaboration with any company employing him, then is it possible to safeguard this content or study material from being tagged as the property of that company? I hope the message is
Okay.
clear.
Yeah, yeah. Thank you. So the thing is, when you outsource your copyright, the primary thing in that is that you draw out a contract. You have to decide on the mutually agreed upon terms. You hold you can say, all the rights. So the first call or the final call can be or has to be yours only. But yes, if somebody is paying you more than deserving money for that, then sometimes you can say the call becomes theirs. So you have to decide at that point of time whether that excessive money is important or your rights are more important. So it depends upon you finally, because sometimes you have to sacrifice some privileged rights for getting some more money. So that is one
Okay.
part. The part two was you start working on another thing which is not related to your first discovery. So you're free to work on your inventions, or you can say your copyrights, which are not related to your original product. It is not a variation of that. For example, you outsource your copyright and start making a variation of it. That is actually breach of trust, I would say.
Yes.
So that should not be, you can say, that territory should not be ventured into. So what I
Yeah.
believe is that we should work on an alternative or totally different thing. That is, I hope I have got the question right in
Yeah,
terms
yeah,
of
yeah. You have answered it very right. I just want to add something here. So, suppose somebody gets a legal document done with a party. I hope these terms will be very clearly mentioned in that document that you are supposed to. This is what is in your right, and you are not supposed to cross this. Will that be in a legal language clearly mentioned there?
Yes, absolutely. The legal contracts are, you can say, done by the attorneys and the lawyers, and they have formats for that. You can always, you can say, make or break the clauses whichever suitable to you. As I said, if the driving force is the money, then the company has the upper say. If
Yes.
not, then you have the upper say, or you should
Right.
have the upper say, I believe.
Great. Great. Okay. Now we have completed all the questions sent by our registered delegates. Now we will take from the live audience. The first one is, can we apply for patent for a technique?
Yes, yes, I mentioned that you always can if it is your method of working. Dr. Rajshekhar also mentioned about the technique only when he had the patent part. So it is absolutely, you can even apply for a, you can say a design also. You can for a ornamental change also, as or a morphological change also. You can apply for that. The only thing, it should not be existing first. And
Yes.
as I said, the government way of working is the FER, first examination report, and then they publish in the journal to invite any objections. And if there are no objections, then after all the paperwork and formalities, the patent is granted to you. That is the way it is done.
Okay.
Yeah.
Great. Next question. I am having a few innovative ideas and currently using it in my practice. How to proceed further?
If you feel that your ideas have a designated end, you can say end post or an end design, then you can apply for a provisional part yourself. You maximum spend rupees 1600 in the start. The 4000 out of the 5600 you pay later on. Anyways, if you don't complete, you lose only 1600 rupees. Because if there is a something, you can say, a unique idea with you, and you need some more time to work on it, patent should not be delayed. As Dr. Rajshekhar also mentioned, we should not be delaying. We should be knowing about it, that this is the first part. If you are, you can say, in that space where you believe that things can get leaked, then you should apply for it provisionally. You can complete the formalities within 1 year. All the documentation can be completed within 1 year. The government officially allows it. The IPR department allows it in that sense. So you should be, but yes, your end should be clear with you, and you should not be demonstrating that in the public space. Because once demonstrated in the public space, that becomes a public property that never remains your property.
Okay. So I think this is the last question. Can we take IPR for some innovative treatment protocol developed to manage a disease?
Absolutely yes. Absolutely yes. You can document all those things. You can say make a protocol for that. If a checklist can have a copyright, why can't a innovative treatment protocol can happen? So it's absolutely in the boundary of that.
So in short, if somebody thinks he has got an original idea, he should just approach an expert and just get the research done, and the FER by the examining officer will tell whether it is possible or not. So instead of
So
thinking
the first,
within
yeah,
oneself,
the
they should just start the process and go for that provisional patent.
they can immediately search on that iprsearch.ipindia.gov.in. They can
Yes,
immediately search for that thing, whether that thing is already existing in the public domain or not. If that is existing, then you start working on something else. If that is
correct.
not there, then you start building on that gradually. You can say once you know that the path is clear, then start a little bit more work on that and apply for the provisional stuff first.
Right, right, right.
Yeah.
Awesome. I think
Rajiv, as
we
I
have completed.
mentioned,
Yes,
yeah,
sir. Yes, sir. Go ahead,
yeah,
sir.
yeah.
We have completed all
Sorry
the
to,
questions.
as I mentioned
Yeah,
initially, the
you can
moment
add.
you get that spark, okay, yeah, no, the moment you get that spark, na idea, so immediately
Yes,
you do it. All right, search. If that idea is innovative, original, then definitely you'll get it. Definitely. But you shouldn't wait, and you shouldn't disclose, as Dr. Bhavdeep said. All right. Then
yes.
once you
Great.
disclose or present somewhere the unique idea, so you cannot do it.
So when we were
Social
discussing
media
before
helps
the
in
lecture,
so-
when we were discussing before
social
the
media.
lecture, and I asked Dr. Halli if he can share all the details of the things, he said, I will share only those things which I am comfortable sharing, because some things cannot be disclosed. That time I realized how important it is. And I'm so happy that we
Yeah.
got the
No, there is
two
something
most
called as
non-disclosure.
there is something called as trade secret. If at all you are planning to commercialize or do things like that.
Yes,
So in
yes.
such cases, we actually cannot disclose the design or the utility patent. I already have two utility patents of such, okay, which are valid for
Okay.
20 years now. So let me see how it will go.
But great, sir. I must appreciate you. Kudos to you for coming up with owning 9 patents and 3 copyrights. And I am sure that is still a long journey
Thank
ahead
you.
lies in front of you, and you are going to accomplish a lot more. And maybe after a few years, again, we'll have the same session. The numbers would have gone up, and again, Bhavdeep will be here to add a few more things that have come up in the law, and how he will, in his own way, can simplify things for people who want to make use of this. So, thank you, Dr.
Right.
Rajshekar Ali and Dr. Bhavdeep Singh Ahuja, for being a part of this event and adding so much value to this theme of today's episode, driving innovation and fostering growth. I'm sure all the participants have received a lot of benefit on this topic. And of course, those who registered but could not attend the live session, tomorrow or maybe in 2 days, we'll be sending out the summary of this lecture along with the link to the recorded lecture. So you can again come back to our YouTube channel of ICPA or Facebook page of ICPA and watch it again. So once again, to our esteemed speakers and all the audience, thank you for joining in. And soon we'll be coming up with the announcement of episode 6 of season 2 of ICPA Clinical Series. Thank you, Dr. Bhavdeep. Thank you, Dr. Halli. See you again in some another event soon.
Thank you, Rajiv. Thank you.
Bye.
Sure. It was a pleasure.
Thank you.
Thank you.